Hello, everyone, and welcome to CDLE's Compliance Quarterly Live Webinar. We're going to get started in just a moment. Looks like we still have a few folks joining our Zoom. We're also live streaming on YouTube, so we will get started in just a few minutes while we get a few more folks to join us. All right, everyone, I think we can go ahead and get started. It looks like our participant list is slowing down slightly. Welcome to CDLE's Compliance Quarterly Live Webinar. This is when all of our regulatory divisions provide updates and answer questions for employers to help you remain in compliance with all of Colorado's various labor laws. I'm Jessica Smith, the department's PIO, and I will be introducing you to our division leaders as we go through today's rundown. So let's go ahead and get started. A couple of housekeeping items for everyone here. We do have the chat disabled for our participants. However, our panelists will be sharing links and providing information via the chat. If you have questions, please use the Q&A function on your Zoom dashboard. We'll answer as many questions as we can within the hour that we have with you today. We're also streaming live on YouTube, so those of you watching on YouTube, feel free to ask your questions in the comment section, and we will get to those as well. So we'll be answering questions from both Zoom and YouTube. What else? Let's see. Shortly following the webinar, we will publish the recording on our website. We'll also follow up with an email with a recording and a copy of the slide deck and the Q&A either today or tomorrow to everyone who registered. With that, we can go ahead and get started. We're going to start with the Division of Family and Medical Leave Insurance and go through our other regulatory divisions listed here. And with that, I am going to introduce Rachel McCombs with the Family Division. Rachel?
Thank you, Jessica, and good morning, everyone. Thanks for letting us carve out a little bit of the day with you today to go over some important updates for family. Just really quick to orient everybody to family and a little bit more information about it in case you're not familiar. The family program was approved by voters in 2020, and it ensures that Colorado workers have access to paid leave during life events that pull them away from work. It's a social insurance program with both employers and employees contributing to the fund that will eventually pay out those benefits. The benefits will be paid out over up to 12 weeks of paid leave for Colorado workers who take care of themselves or their loved ones during that time off. And those who experience childbirth or pregnancy complications may be eligible for an additional 4 weeks for a total of up to 16 weeks. The life events that make Colorado workers eligible for benefits include managing a serious health condition, making arrangements because of a military deployment, taking care of a family member's serious health condition, or to deal with the immediate needs and impacts arising from domestic partner violence or sexual assault. The program covers almost all workers in Colorado, including those who are self-employed and employees of opted out local governments who opt out individually. Looking at a little bit more information about what you need to know right now this quarter, want to share some reminders with folks. So as a reminder, there were rules adopted in November of 2024 that took effect January 1st, 2025 of this year. That explained that employer entities with multiple branches that have different federal employer identification numbers or FEINs are considered by the division to be separate employers with separate rights and obligations. So what this means is that all member employers must register a family account for each separate FEIN. So for those professional employer organizations or PEOs, you must report wages under the family IDs assigned to each member employer. So I wanted to clarify that. Employers with 9 or few employees must register as soon as possible to ensure proper federal taxation of family benefits for their employers. This is as a result of recent guidance from the IRS that states that if an employee takes leave to care for their own serious health condition, the taxation rate of those benefits depends on the headcount of the employer. So that's all new stuff that's coming out. So we are going to be providing more information on that, but want to make sure that you know that if you have 9 or few employees, you must register as soon as possible. Self-employed individuals who are voluntarily participating in family, they must upload their prior year tax transcripts and W-2s by December 1st, 2025. So individuals should request their tax transcripts and W-2s by visiting Get Your Tax Records and Transcripts page on the IRS website. If the tax transcript and W-2 have not been shared with family by December 1st, 2025, the My Family Plus employer the system will automatically set account eligibility to a null status, which means the individual will not be approved for their family benefit payments. So it's really important to take care of that. Moving on to a few more need to knows. There's been some amendments to rules 7 CCR 1107-1 through 1107-9 have moved through the rulemaking process and are now adopted. So we're excited about that. These amendments will go into effect July 1st, 2025. The amended rules are now published on Families Rules and Guidance website, so definitely check that out. Here's what they concern. So military spouses. A military spouse can be localized to Colorado and covered by the family program, even if the military spouse's residency relief act says that their wages aren't earned in Colorado for tax purposes. Also impacted by this is private plan coverage. So if an employer's coverage under a private plan lapses or ends, their state plan coverage begins on the date of the lapse. And then also job protection. Individuals on intermittent leave or reduced leave schedule may acquire job protection status during their leave because their leave commences with each new absence. And then lastly, regarding retaliation. If a retaliatory termination causes an employee to be ineligible for benefits, the value of those lost benefits is includable in damages in a damages calculation. As far as tech updates go, among many enhancements that we were making across the various portals, our latest releases have streamlined the designated representative experience. Benefit staff can view a DR overview of claims, including contact details and a banner indicating a DR management, or DR stands for designated representative. And then benefits staff can view read-only versions of that designated representative work item from the claim summary screen, making the form completion easier for all involved. And then last but not least, speaking about resources that we have available, we have several resources and toolkits to help you through all of your employer obligations. Those are available on family.colorado.gov, and they include file specifications and templates for wage reporting. You can also find user guides and how-to videos there. There's also various tools to help you communicate with staff. Employer clients may serve or other partners who would benefit from learning about family. So any of the posters or notices or anything like that that you would need that would be helpful to have on hand, you can find those there. And as well, the newly adopted rules and the supplemental guidance is published on Families Rules and Guidance page, also found at family.colorado.gov. And with that, that concludes Families updates for you this quarter. And I am going to hand you off to my colleague, Megan Culp at the Division of Unemployment Insurance.
Good morning, and thanks, Rachel. My name is Megan Culp. I'm with the Division of Unemployment Insurance over the employer services side. Unemployment insurance is a wonderful program similar to Family that is designed to help people, workers who have lost their jobs due to no fault of their own. So the unemployment insurance program will provide that temporary wage replacement for those individuals. The wages come from the UI Trust Fund. So that trust fund is made up fully of contributions made by Colorado employers or nationwide employers who have Colorado employees. And those benefits are then paid out of that fund. So certainly a really great safety net program for the citizens of Colorado. What you need to know generally about the division at this time. Some updates for us as of just last month, April 3rd. UI is no longer sending employer fact-finding requests in the mail. So this is a new change with a regulatory update where employers are now required to respond to any fact-finding sent related to separated employees by division approved electronic means. So right now, those include the MyUI Plus system, MyUI Employer Plus for those who are the employer side. And then also we will accept fact-finding through the state state exchange, data exchange, the sides exchange. And that is also if you work with a third-party administrator such as Talks or TriNet, there is a portal that they can use as well. Something upcoming for the next calendar year, but is being applied currently. As of June 30th, we have what is called a delinquent premium penalty that can be applied to your employer UI account if you have unpaid balances from prior quarters as of that June 30th date. So really important for you all to just take a look at your UI accounts as they stand today and make sure that there are no lingering balances so that you don't have that delinquent premium penalty assessed in 2026. And then just a quick reminder for you all that if you do use a third-party administrator, you must have granted them permission to have specific roles to interact with your account. So the main roles are going to be responding to fact-finding and also providing wage reports and payments on your behalf quarterly. So within your employer portal in the MyUI Employer Plus system, you have the capability to either approve a request made by your third-party administrator or to initiate a request directly. And we have some really great guides and resources on our website. I know you don't have access to the slide deck quite yet, but those will be linked here. They're also available at coloradoui.gov under the employer heading. And then just a brief tech update here. If an employer account that you have with us does not have an email on file, whether because you use a third-party administrator, you don't directly interact with the division through that account, the fact-finding request will be sent either to your UI inbox. So that is the account inbox associated with your UI employer account. They are not going to be sent by mail. So if you aren't using a third-party administrator and you don't have that email on file, it will be housed for you in that inbox. So please reach out to us. We can help you get logged in. We can help you get that email associated with your account. But if you don't have that information, the information is still available to you inside of your MyUI Employer Plus account in your inbox. And then the State Information Data Exchange System, which I was referencing earlier and couldn't remember the full acronym, that's the SIDE system. That is the system that allows you to electronically interact with us for fact-finding. And that is something used by both employers and TPAs. And you can now log into that system, the eSIDE system, from within your MyUI Employer Plus account, which is a great enhancement. And then, as with family, we all also have some really great user resources on our website. These include toolkits that can kind of give you a play-by-play way to interact with our system for the various use cases, such as submitting a report. How do you get data out of the system, such as a 940 certification for the IRS? How do I adjust wages? We also have other ways for you to interact and gain more information from us, such as the employer monthly email sign up and TPA monthly email sign up. And I believe that is it for UI, and I'm going to hand it over to my colleague, Amy Kingston with Division of Workers' Compensation.
Thank you so much, Megan. Hi, Amy Kingston. I'm the Manager of Claims and Employer Programs with the Division of Work Comp. Just a little background about workers' compensation. Our program offers wage loss benefits and medical benefits to workers who are injured at work. But the role of the division is unlike UI and unlike family, we don't actually provide benefits. Our role is more of a regulatory role. So we look at the rules and the process, and we make sure that all the parties involved in our system are following those rules. Workers' compensation is typically paid by insurance carriers. These carriers it's just policies bought by employers who then, when an injured worker reports an injury, they report that to their carrier, and then that's who actually pays the benefits. But the division does offer a process if there's any disputes between any of the parties regarding what benefits ought to be paid or if benefits should be paid at all. Next slide, please. Some of the recent rules and regulations that have passed and that will become effective. We recently had a public hearing for our Rule 16 utilization standards. That rule looks at our medical process and how we determine whether or not medical benefits ought to be paid to an employee. That will be effective on July 1st. Another rule that will be effective on July 1st is our Rule 2, which looked at our surcharges. The Division of Work Comp is paid by a small surcharge that's added to every single worker compensation policy. We did not change that this year. It still remains what it was last year. We recently updated Rule 11. That rule involves our division independent medical examination, also known as the DIME. The DIME is an opportunity for injured workers to get a second opinion on whether or not they need additional treatment after reaching maximum medical improvement and whether or not they have a permanent impairment. We made some substantial changes to that rule, including increased very significantly the amount that a physician gets paid if they conduct these examinations, and also how those medical records get delivered to those doctors. If you have any specific requests or questions, I highly recommend reaching out to our DIME unit because it is pretty technical. We also, starting on January 1st, 2026, so in a little while, all insurance carriers must accept electronic medical bills from providers. This is actually pretty standard throughout any industry which involves medical providers billing insurance carriers. This is not something new. This is just something that we are now requiring within workers' compensation as well. If you have any questions regarding this one, please reach out to Christy Culkin. She is the expert when it comes to billing for medical. We have one significant tech update, which has two prongs. So we are modernization. We are going through a modernization process that will update our claims management system. This means that injured workers, employers, attorneys, medical providers, anyone who's involved in our system can look directly at our information and find out exactly where they are within the claims process. This is happening right now. We are literally programming what this new program will look like. So if anyone out there has any opinion or have had some experience with workers' compensation and would like to give us feedback on what you think the new program should offer, please give us feedback. Like I said, we are literally programming it right now. And so we do have an opportunity to take back feedback and make it a program that everyone will be able to utilize. At the same time, We are updating our EDI, which stands for Electronic Data Interchange Program. We are moving from 1.0 to 3.1. It's a very big jump, but it will mean that third-party administrators, insurance carriers, and self-insured employers can tell us, the division, about claims electronically. Both of these updates will go live in summer of 2026. We also have some new resources and toolkits. We recently premiered our Workers' Compensation 101, which is a short video that discusses the benefits that are offered to injured workers. What are the wage benefits? What are the medical benefits? How does the process work in general? This is aimed at injured workers. However, I recommend that anyone who touches the system and may be a little unaware of how it works, watch it, share it with employees so they can learn how this system works. We also have a recording regarding our new dime changes. It's a webinar. Like I said, they were pretty significant. So if you'd like to take a deeper dive on that, that webinar is now posted on our website. Next slide, please. We have a few upcoming engagement opportunities. One is one that happens every month. So on the third Thursday of every month, our judges review all the case law, meaning any orders that came from the Industrial Claims Appeals Office, Court of Appeals, or the Supreme Court that involves workers' compensation. They look at those cases, summarize them, and give their opinions on them. Like I said, that's every third Thursday. They're also available on our website. And we are also inviting people to come to our claims management Q&A webinar that will happen on June 26th. Claims management is going to give any answers to any questions you might have. We invite people to submit them prior. Of course, if you have a question while the webinar is going on, we'll be handling those as well. However, if you happen to think, I don't have any questions, but I would love to hear what other people have questions about, please come. You will definitely learn a lot about how claims management is handled in the state of Colorado. Now I am turning it over to Peggy Christian with OPS.
Good morning, everyone. Thanks for attending this webinar. I'm introducing the Division of Oil and Public Safety. We have several sections within OPS. The first is amusement ride and devices. We regulate any amusement ride in the state of Colorado, whether it is a stationary program or if it is a traveling carnival that happens throughout Colorado during this summertime. All devices have to register with the Division of Oil and Public Safety. They will receive a permit that they have to post somewhere on the property. Our explosives program ensures the safety of workers and the public. And it protects property of the individuals and businesses that use, manufacture, possess, sell, or store regulations and blasting agents. Next is our boiler inspection program. They do periodic inspections. We have state inspectors, and we also have special insurance inspectors that we commission to do the inspections in the state of Colorado. They are performed to verify compliance and that they also follow the safety that is required by our program. Petroleum program has several sections. Our first one is the compliance section, and that monitors products quality. It ensures accurate measurement of the fuel product that you dispense into your vehicle. The remediation program steps in when there is a product spill, and they will ensure that owners and operators conduct cleanups in a timely manner. They also provide technical guidance related to release responses. We also have a petroleum storage tank fund, and they receive and process applications for reimbursements of the costs related to the assessment and cleanup of the petroleum contamination. Our final petroleum of that group is we oversee the retail of liquefied petroleum gas, which is LPG, compressed natural gas, CNG, and liquefied natural gas. We oversee operation of retail hydrogen fueling facilities as well. Excuse me. Our conveyance program is relatively new. We license third-party inspectors to perform the inspections of all elevators, escalators, wheelchair lifts. We also do automated people movers, which would be the train at DIA. The program delegates regulatory authority to municipalities, counties, and other authorities having jurisdictions. And those agencies need to follow our regulation. They can be more stringent than us, but they have to at least follow what our regulations are. And last but not least, we have Underground Damage Prevention Safety Commission, and they have the enforcement oversight of the One Call law. And the next slide. We have a couple of regulation that have been proposed, and we are having stakeholder meetings. The first one is the boiler program stakeholder meeting, and that is Thursday, May 29th at 10 a.m. And that is virtual, so you can attend that online. And our conveyance stakeholder meeting, our stakeholder meeting has been scheduled for June 4th at 1 p.m. One thing that is not on the slide is that we'll begin engaging with stakeholders on EV charging regulations pursuant to the bill that was just passed this session, which is HB 1267. And next slide. OPS sends out quarterly bulletins for all of our programs. So when you get this slide deck, please click the links on what you're interested in and register for our quarterly bulletins. You will also receive e-blasts and notifications of our regulations. We also have a guidance document on our website, and we're in the process of revamping it and making it user-friendly for the public so they can use it on their mobile devices, iPads, whatever they use in the field. So stay tuned. That's being updated in sections because it is so large. And I think upcoming events. We have every 3 years we do outreaches, and this year our first one is August 20th, and that is in Grand Junction. And then we have another one in the Denver metro area. And stay tuned to our website, and we will have additional information once we solidify venues and that type of thing. So that is what's going on with OPS, and I'm going to introduce you to Christina Rosette in DLSS.
Thank you, Peggy. Hi, I'm Christina Rosette from Division of Labor Standards and Statistics. A kind of broad overview of what we do. We administer various labor laws through enforcement, publishing guidance, and offering compliance assistance to employers. Of the varied topics, wage and hour is our largest area of work. We oversee minimum wage, overtime, deductions, rest and meal breaks, and then as of 2020, paid sick leave that Coloradans are entitled to under the Healthy Families and Workplaces Act. We also have authority over sex-based pay disparity in our unequal pay program and job transparency requirements, which include pay that must be detailed in job postings, applicant screening limits, like when and what can be asked about criminal history during a job application process, and disclosures for transportation and delivery network companies um, that are required to be made to consumers of those companies and to drivers for those companies. We have a limited scope of authority over labor relations or union law. Most of that is handled at the federal level, but what we do oversee are private sector union dues elections, some private sector union rights in industries that aren't covered under federal law, like agriculture, and public sector employee organizing and representation elections. We oversee farm work conditions, heat protections, shade, water, use of certain tools, or limits on hand weeding that can be done by farm workers. And then finally, retaliation protections for folks um, exercising any of the rights of the other programs that we oversee. So, because it's a lot, sometimes it's more helpful to also look at what we don't cover. We don't cover discrimination, harassment, or accommodation. Those topics fall under the Colorado Civil Rights Division in the Department of Regulatory Agencies. And then, of course, we don't cover benefits like family, unemployment, workers' compensation. Those detailed by my colleagues on the call are other divisions of the department. And we have good relationships with all these other folks. So if people get to us, we can, of course, point you in the right direction. What's new for us right now? This quarter, we wanted to highlight some of our guidance. We recently updated, including with a new name, our labor law and guidance and education webpage, which has various different tools that employers can use to understand their obligations under the laws that we enforce. So our big one is interpretive notice and formal opinions, or info sheets. These are our official approved notices, opinions, and explanations of the various labor law topics that we enforce. We have 23 of them, some with subparts, so we really try to cover our bases in explaining all of the various laws we administer. We also have one page kind of know your rights summaries for employees called Knowledges, which stands for Knowledge for Workers on Labor Law is Empowering and Drives Good Employment. The knowledge sheet number 1 is kind of a general overview of employment rules like overtime and rest breaks. And then knowledges 2, 3, and 4 are targeted for employees in specific industries with plans to continue that work and add additional sheets in the future. And then our newest offering as of within the last few months is our labor law videos. So under 5-minute videos on basic labor law topics. Again, we have 3 right now with more planned to be in the hopper. And that just kind of gives you bite-sized information about particular things like break time, final pay, impermissible deductions. And on that page, we also have other public guidance like notices and reports that the division publishes. So we aim to have a lot of resources and different ways to digest the information. But of course, if you're not finding what you're looking for, we take email inquiries and operate a call center to answer questions about our laws. And with that, I'm sending it back to Jessica for more Q&A.
Thanks, Christina, and thanks to all of our division leaders for presenting today. Just a quick reminder, if you have questions, please drop them into the Q&A function on Zoom. For those of you watching on YouTube, if you have questions, put them in a comment and we will answer those verbally. I'm going to start with a question from this one is for Megan Culp in UI. The question is, this employer has tried to report earnings, but is getting stuck on a unit number. I'm new to this. Can you remind me what a unit number is? Mine says 0000.
Yeah, thanks, Jessica. We had unit numbers historically to differentiate work sites. So, if you owned several Subway shops, as an example, occasionally you may have your stock or base employer account number plus a unit number to differentiate the locations. We have since consolidated everything into your primary UI account across all employer types. So, that unit number should just always remain as kind of this hanging placeholder. Zero is just fine. It won't impact any claims processing or wage filing.
Thank you, Megan. I'm going to move over to DLSS. Christina, this question is for you. The question is it on-call pay covered by DLSS? If so, what is the on-call pay for Colorado? Is it mandatory to pay for on-call? I know some states do not require on-call hours to be paid.
Yeah, thanks for the question. On-call pay can qualify as time worked that must be paid under Colorado law, depending on the circumstances of the on-call nature of it. If you like the amount of flexibility you have to attend to personal matters during the on-call time, or how soon you must return back to the work site to attend to work. The best resource for that is our info number 20 series on time worked, and I can provide a link for that in the comments.
Thanks, Christina. We've got a lot of questions in the Q&A about family for self-employed individuals. I'm hoping to capture a couple of them here by simplifying, but where is the best place for the self-employed individuals to upload their W-2s in My Family Plus Employer? Rachel, are you able to answer that, or can David or Evan jump in?
I can take that, Jessica.
Thank you.
Yeah, thanks. So in the My Family Plus Employer portal, you have the option in there to upload and share documents with the division. So that's where you would upload those.
Thank you, Rachel. Let's see here. Megan, we have a question here for UI. The question is, we have an ex-employee who has been unable to open their UI claim because of their ID.me account is tied to a phone number they no longer have. Is there a contact that could help with this issue if they have tried online, but haven't gotten anywhere? So what's the best advice for this person?
Yeah, my recommendation is there is an escalations option within that individual's MyUI Plus account. Even if they do not have an active claim, they can establish that MyUI Plus login. And within that, they can escalate based on their issue. They can also call our call center. I know that's never the best option for folks to sit on hold and wait, but occasionally these do need that human touch. So those are the two kind of escalation points that I would recommend.
Thanks, Megan. Our next question here is both for UI and family. I think it might be easier to start with family. So David, if you could answer this, are we required to pay UI and family for part-time employees who work 5 hours a couple of days per week?
Yeah. So for the purposes of family, yes, there's not a restriction on days worked, assuming that you are a covered employer, which the vast majority of employers in the state of Colorado are. But we don't exempt individuals from participation in family based on the work schedule, number of days worked, number of hours worked. If they're working, then those wages should be reported.
Thanks, David. Megan, is there anything you'd like to add for the UI perspective?
Yes, just a little bit different. So for UI, we typically have for standard employers, these are your regular business owners that aren't falling into like a nonprofit category or government agency. You do have a wage threshold. So typically that's $1,500 paid to any employee in a calendar quarter. It's a pretty low threshold. So most people meet that specific criteria. Additionally, if you do have somebody that's just very, very, very part-time, we have a 20-week criteria. So if that person is working 1 hour in a week in some portion of that week, right, over 20 calendar weeks, you would still qualify. So 20 calendar weeks is about 6 months. So there are situations where you may fall below that 20-week threshold and below that $1,500 threshold. If that's your kind of little sweet spot, you don't have to pay unemployment insurance premiums on that individual, or generally if that's your only employee. But most people will meet the criteria usually on one employee.
Thanks, Megan. My next question, we're going to hand it back over to DLSS. So Christina, this one is for you. The question is, how is sick pay handled for commission-based employees who typically make up lost income by rescheduling clients?
Yeah, so HIFWA sick pay is generally at the same rate, the same salary as employees earn during their normal hours. For commissioned employees, if they're paid both an hourly, weekly, monthly, regular wage and on commission, the employee's rate for the leave is the base rate or the applicable minimum wage, whichever is higher. And if there's not a base rate, then the leave rate includes any set hourly or salary rates, shift differentials, tip credits, and commissions under the wage protection rules. And that is detailed in our info number 6B.
Thanks, Christina. I believe this question is for Megan in UI. The question is, when will the fiscal year 25-26 pay plan post?
I don't know if that is a question for us. It might be family, but I don't have an answer to that question, Jessica.
Thank you. Anonymous, who asked the question, if you'd like to re-ask the question with a little bit more context in relation to what specific division you're referring to, that'd be great, and we can get back to it. Let's see here. We've answered over 55 questions, so thank you to all of our division leaders who are typing out answers furiously in the Q&A function. I'm gonna ask Evan Grimes to answer this question for family. The question is, when will private plan participants see the administrative fee from the state for being on a private plan?
We should have more information and reach out to employers with that information before the end of November of this year.
Thank you, Evan. Let's see here. Here's another question I believe will be for Christina over in DLSS. The question is, if you get a raise while you're on sick leave, how does the, or potentially this is for a family, how does the private insurance carrier know that this person got a raise while on leave? And is there a procedure for increasing their wage base, i.e. they aren't receiving max benefit and they got a raise, which might allow them to get their max benefit? I think that might be for family.
Yeah, so for family, we're looking at uh, a previously completed quarter to determine the average weekly wage, and that determines the benefits. So where this situation would come up is where somebody is on leave at the conclusion of a quarter, and they have a quarter that then flows into their base period and it becomes completed. In that case, we would be looking at their wage reports and calculating out the appropriate benefits. We don't recalculate benefits in flight based on a change in wages. So this is really kind of something irrelevant. But what they could do would be to conclude their claim and file a new claim.
Thanks, David. Keeping on with the topic of family and coordination of leave benefits, another question is, can we mandate the employee to use Colorado's family plan at the same time as our employer plan?
Yeah, and so this is a question we get a lot about: how does family interact with your employer provided plans? So let's start with, if you have some form of PTO or annual leave, you can't require an employee to use that leave before or during family. You can agree with the employee to use that for a top off. But other types of programs, like let's say that you offer a short-term disability program or you have a parental leave program, those programs, they really don't interact with family a whole lot. So there's nothing that the employer does that's going to alter somebody's entitlement to family benefits. If somebody's entitled to take benefits, to receive benefits and take leave, they are, regardless of what the employer does. So they're able to come file a claim with us. We'll review it. If we approve it, they're on leave and they get those benefits. So all of the leeway to adjust benefits is going to lie with the employer. So if you have one of those types of programs, as an employer, you can modify that program really however you want to interact and work with family. So there's a lot of different ways you can do that. You can tell employees that they have to use all their family benefits before they can access your employer provided program. You can use the employer provided program as a top off to bring that employee up to 100%. Uh, some employers have looked at the family benefits and said, hey, that's better than what we were offering. So everybody go use family, and we're going to save money on not offering these programs anymore. So as an employer, you can and you definitely should take a look at how your programs are operating and adjust them how it works best for you. To interact with family, but we're not going to alter the family benefits. There's nothing that you would do that would restrict or reduce somebody's ability to access that leave.
Thanks, David. I'm going to stick on the topic of family for a little bit. We have a question from our YouTube audience. The question is, how many employees do we have to offer benefits? David, that's for you.
Yeah, so family applies to all employers regardless of size. So there is not a limitation on number of employees. What number of employees will change is the amount of premiums you're paying. So if you have 10 or more employees, the premium is 0.9%, and you can deduct up to half of that from employee wages. If you got less than that, the premium is 0.45%, and you can deduct all of that from the employee's wages. But in terms of participating in family, in terms of paying premiums, in terms of receiving benefits, there's no cutoff on size. That applies to all employers.
Thanks, David. Let's see here. Of course, the question that I was going to answer just disappeared. One second. Let's see if we can get a new topic here. Lots of sick leave and family questions. Okay. I'm going to stick with family because all of them are family questions. David, I believe this is for self-employed individuals. Evan or Rachel, feel free to jump in if you have more to offer. But the question is, are the current 2025 W-4s mandatory? They were using the 2019 W-4.
Yeah, yes. I mean, you can't use a 2019 W-4, so you need to use the most current W-4.
Thank you, Rachel. Rachel, maybe you can answer this next one too. How long does it typically take for a reconsideration of your annual employee headcount take for a family if an employer has requested that reconsideration?
So this depends. Right now, depending on how many employees, depending on how big the employer is, will determine how long it takes to re-verify. Typically, it's taking a few weeks. But if there's a specific employer that, if you want to reach out offline and you're running into any issues with your update, you can let us know and we can look into that one specifically to see if it's taking longer than a couple weeks.
Thanks, Rachel.
Yep.
This one might be related to family, but the question specifically references just sick leave, so it might also relate to HIFWA. So Christina, if you can answer this first, and then we can answer it again from the perspective of the family division, that'd be great. The question is, can an employer ask the employee who is using sick leave if we suspect that they're using it for vacation, or can we deny it? I understand that we can't request a doctor note until after at least day 4.
I'm so sorry. I think I got booted out right as we were
Oh,
reading the question.
mhm.
Generally, answer is not no, not if just suspected. With HIFWA rights include protections against interference for employees asserting their rights to use that leave, and that's consistent with the documentation requirement for longer leave. And again, I'll plug our info series. Info 6B details procedures around employees' request for leave, the documentation side of it, and all of that.
Thanks, Christina. David, is there anything else you'd like to add from the family side of things?
Yeah, and I do think that question was directed at HIFWA, but as far as family goes, uh, if you have a suspicion that somebody is engaging in fraud, you can definitely report that through our website. But I would not suggest, as an employer, engaging in investigations of employees who are accessing family and who have approved family leave. Uh, so yeah, if we've approved the leave, you can't require a sick note, and I would suggest not hiring a private investigator to tail somebody. But again, if you do think somebody's committing fraud, please let us know. You can contact us on our website. Where you're more likely to see that is going to be having an employee who you know isn't out on leave, uh, who is sitting in the office, and you get a notice that they're out on leave. And that would be an indicator that potentially they've been a victim of identity theft. And also with that, let us know if you see that kind of fraud going on so that we can address it and protect their identity.
Thanks, David. I have another question for you for family from our YouTube audience. The question is, can an employee opt out of family?
No, this is program participation's mandatory. It's like workers' compensation in that way. It covers all employees in the state of Colorado with very few exceptions, mainly federal employees and railroad workers. And any contract purporting to opt out or restrict it isn't valid. So it does cover everybody, and all employees are required to participate and pay in premiums, and then they are eligible as well for benefits.
Thanks, David. I'm going to stick with you for a minute. Also from YouTube, we are a home care agency just starting out and have just a few employees. Do we have to give benefits? All of the employees are part-time.
Well, so in terms of employer provided benefits, no, there's not a requirement out there that employers offer any type of benefits other than those ones that Christina described, the HIFWA, the Healthy Families leave. But yes, as an employer, you are required to participate in family, and those employees would be eligible to take leave under family and to receive benefits. But we're going to pay those benefits. The state agency pays those benefits. The employer does not.
Thank you, David. Also from YouTube, Chris is asking, what are the requirements for governments and special districts to opt out of family?
So there are some very specific requirements in our rules, and I would suggest that any special district that is considering an opt-out speak with their counsel regarding that to make sure that they're in compliance. But in general, you have to have notice to your employees. You have to follow your established decision-making process. So most special districts, most government entities are going to have some sort of a board that oversees that, and they're going to have their bylaws for conducting their meetings, complying, of course, with the open meetings law, conducting their votes. And then once all that happens, you can give us notice. But again, there are some very specific requirements there, so highly suggest consulting with counsel on that.
Thank you, David. Another coordination of benefits question. Can an employer stop the accrual of PTO and sick time during family leave?
Evan, can you weigh in on that?
Sure, but with limitations. Nothing under the Family Act requires an employer to maintain leave accrual. The benefits that an employer has to maintain during family leave is the healthcare benefits. But I always say that's a limited answer because I want to make sure that when I say that nothing under family law requires that, something under some other law might. And so those employers are highly encouraged to consult with legal counsel to make sure that there's not something else that might be requiring them to maintain that accrual while the employee is out on family leave.
Thanks, Evan. David, can you answer this question? Can a sole proprietor who is not an S corp with a W-2 enroll in family?
Yes. Yeah, the S corps actually complicate everything. If you're a sole proprietor, if you have no business entity, if you are an LLC, you can participate in family, and there are guides on our website that will help you do that.
Thank you, David. We have a question here from Diane. She's asking, where can we find laws regarding sick leave? Christina and or someone on the family team, can you drop some links in the Zoom chat here to the relevant infos and resources for the family division, just on where Diane can find more information about the laws regarding sick leave? I think she's specifically asking about HIFWA. So Christina, if you could drop those links in the chat on Zoom, that would be great.
Will do.
Thank you. Another question for family. David, wouldn't modifying the program for just Colorado employees be considered discrimination to the other employees who don't work in Colorado?
Right. And this one, I think, is a follow-up to one I answered in text. So, but what we're talking about here is that coordination of benefits. And what do you do if you have employees nationwide? How do you get those programs to work together? And as I told you all, the employer has a lot of leeway to modify that program, right? And so the question here is, can I modify employer provided leave just for Colorado employees? And the answer is yes. There's not a requirement that employees in different states be treated the same. Now, big asterisk here, that's under Colorado law. That is to the extent I'm qualified to answer it under federal law. If you have some sort of particularly a collective bargaining agreement, you want to take a look at that because that may restrict your ability to modify the program. But that's not something we have jurisdiction over. So yeah, it's up to employers on how they want to handle that when you've got employees in multiple states. But you are allowed to modify the programs for your employees in specific states to take into account the family program in Colorado or PFML programs in other states that may offer them.
Thank you, David. We have another question here about W-4s, and I want to be clear that I'm saying W-4, not W-2. The question is there a better resource for understanding how to use the new W-4? This is a anonymous question, so if you want to clarify with more context, whoever is asking this question, feel free to do so. David and or Megan, do you want to answer this in terms of how employers would use the W-4?
I will
It's not a,
yield.
sorry, David, go ahead.
I was just going to say I will yield to you to answer that question.
I was going to mention that it's not a form that unemployment insurance refers to, so I don't have any guidance on this, unfortunately.
David, is that the same for family?
Yes.
Okay, question and answer. If you wouldn't mind re-asking your question with a little bit more context or clarifying whether or not you are referring to your W-2, that would be great. More coordination of benefits questions. The question is, our company provides paid sick leave and PTO. Does it have to be a serious illness, or is it a cold, flu for the employee or child family member count for use of family?
And so we don't have a set minimum amount of leave to use for a claim. We will not pay a claim until somebody requests 8 hours of leave. So if somebody is out for 2 hours for a doctor appointment, they can file a claim. We won't pay it. We'll hold that until there's at least 8 hours to make writing that check worthwhile. So theoretically, yeah, if an employee meets the definition of a serious health condition under our law, which is very broad and includes really anything for which you're receiving treatment or, uh, well, I will just say it's very broad. Uh, then yeah, they could file a claim for benefits and they could access that. Uh, we're not seeing a whole lot of that just because the requirements to get documentation and to file a claim are generally not worth it for most employees for that short period of time. But we do not have a waiting period or a minimum required absence to access family. It is theoretically available for those short-term absences.
Thank you, David. I do want to do a quick time check. We are at time here. We're actually at 12:02. So thank you everyone for joining us today. Thank you to everybody watching on YouTube. Just a reminder, we will send out the recording and a copy of the slide deck as well as a copy of the Q&As to everybody who registered for the webinar either today or tomorrow. The recording will be posted to our website later today, so you can go back and refer to it this afternoon. But again, thank you all for joining us. When we send out the follow-up email, there will be a survey for you to provide feedback on how we're doing and provide any topics that you want to learn more about next quarter. So feel free to fill that out and let us know what you're looking for in August, I believe. Thanks again, everyone.